In Downs versus Bidwell, where they concluded that the Constitution does not by default apply in federal territories. Have you ever been in a court and heard that if you bring up the Constitution again, we will place you in contempt of court? The Constitution absolutely has no bearing in this court. Have you ever heard that? Okay, this is why. It does not apply in what is identified as federal territories and only applies in constitutional states. And that Congress must expressly extend its application to a specific territory in order for it to apply. The personal and civil rights of the inhabitants of the territories are secured to them, as to other citizens, by the principles of constitutional liberty, which restrain all the agencies of government, state and national. To summarize what we are learning in this section from examining the relationship between territories and states of the Union. 1. Possessions and territories are listed in Title 48 of the U.S. Code. 2. Federal territories are statutory states under Title IV U.S.C. subsection 110D and under most acts of Congress. 3. There are no territories left. Puerto Rico used to be a territory but subsequently became a possession. 4. Constitutional states of the Union are foreign and alien in relation to statutory states. 5. Constitutional citizens or nationals are aliens in relation to federal territories and possessions, which is the area that the income tax is limited to. 6. A statutory non-citizen national of the United States under Title 8 U.S.C. subsection 1408, which also falls under Title 28, 3002, 15A, B, and C, from a possession is an alien within a constitutional state and can be deported if he commits crimes. Rabang versus Boyd, 353 U.S. 427, 1957 was the year of the case. An example of such a possession is America Samoa, or Swanee Islands, Swanee, S-W-A-I-N-S, Islands. The Philippines also used to be a possession, but was later emancipated. 7. Statutory national status is a revocable privilege and franchise grant legislatively by Congress and originating from the naturalization powers of Congress. 8. Statutory national status is a component of being either a statutory citizen or a statutory non-citizen of the United States, Title 28, 3002, 15A, B, and C, otherwise identified as a territory, Washington, D.C., District of Columbia, or criminals, under Title 8 U.S.C. subsection 1408. 9. When a possession is granted independence, its inhabitants convert from non-citizen nationals of the United States, Title 28, 3002, 15A, B, and C, belonging to Washington, D.C., District of Columbia, or criminals, to both statutory aliens and constitutional aliens in relation to the national government. 10. Statutory national and citizens of the United States, Title 28, 3002, 15A, B, and C, also identified as U.S. citizens or United States citizens under Title 8 U.S.C. subsection 1401, are much more complicated than all the others. 10.1. An example of such a party is someone born in Puerto Rico. 10.2. The U.S. Supreme Court ruled in Gonzalez versus Williams, 192 U.S. 1, 1904, that such parties are not constitutional aliens, but did so not by looking at whether they were constitutional nationals, but whether Congress made them constitutional aliens or not. Therefore, constitutional nationals and statutory nationals are not synonymous, and their relationship is defined by statute and not organic law. By default, at least, we can say that they are foreign and alien in relation to each other, but Congress can alter that by statute. Counsel for the government contends that the test of Gonzalez's rights was citizen of the United States and not alienage. We do not think so, and on the contrary, are of the opinion that Gonzalez were not an alien within the Act of 1891. The order below was erroneous, conceding to counsel that the general terms alien, citizen, subject are not absolutely inclusive or completely comprehensive, and that, therefore, neither of the numerous definitions of the term alien is necessarily controlling. We, nevertheless, cannot concede, in view of the language of the treaty and of the Act of April 12, 1900, that the word alien, as used in the Act of 1891, embraces the citizens of Puerto Rico. We are not required to discuss the power of Congress in the premise, or the contention of Gonzalez's counsel that the cession of Puerto Rico accomplished the naturalization of its people, or that of Commissioners Degta in his excellent argument as amicus curiae that a citizen of Puerto Rico under the Act of 1900 is necessarily a citizen of the United States. The question is the narrow one, whether Gonzalez was an alien within the meaning of the term as used in the Act of 1891. Gonzalez versus Williams, 192 U.S. 1, 1904. 10.3. In most cases, as in the present, those from Puerto Rico are not designated as constitutional aliens, but that condition is not a result of their statutory citizenship. As such, they are treated as being neither statutory aliens nor constitutional aliens and cannot therefore be deported if they are physically in a constitutional state and commit a crime. In order to convert from a statutory citizen under Title 8 U.S.C. subsection 1401 to a constitutional citizen under the 14th Amendment, one must be naturalized under the authority of Title 8 U.S.C. subsection 1421 and Constitutional Article 1, Section 8, Clause 4. Number 12. When territories become states, Congress collectively naturalizes everyone in the territory by legislative action to convert them from statutory citizens to constitutional citizens. This converts the citizenship from a statutory privilege to a constitutional right, or constitutionally protected right. The citizens and residents mentioned in the Internal Revenue Code are statutory and not constitutional. Hence, states of the Union are foreign and alien in relation to these people. See Section 4.10 later. Lastly, if you would like an excellent history of the extraterritorial application of the protection of the Constitution outside of constitutional states of the Union, we highly recommend the following case. The case doesn't, however, discuss the extraterritorial reach of the 14th Amendment to territories, unfortunately. When we come back, we'll be talking about legal statutory civil status versus political constitutional status.